Hello, friends. Welcome to the Cold War Prepper and Civics 101, U.S. Government. Looks like we got one person on. Don't know who that is. But I am grabbing a real quick bite to eat. I've really pushed things to the limit today. We have a friend, that's what we call the people we help in St. Vincent de Paul, a neighbor. And we decided to drive him 20 miles to another town who has a fantastic food bank. And I thought I was getting him there 15 minutes early. It turned out I was getting him there 45 minutes after it started. So he was like number 255. And at 7 o'clock, they just started working on number 200. So we had to drive back this way, drop him off, and then come home and get everything set up. So running really, really close. So let me get one more bite of strawberries. And but we didn't get him any food. So half a tank of gas for me and mission not accomplished. I feel really terrible about that. Hi, Cats and Prepping. Welcome. Great. Stray Kitten, Holly Ivans, Diana too. We're also going to have another guest, hopefully tonight, who teaches this in high school. So we had a retreat Saturday, and Lori and I were talking, and she teaches government for a high school. I said, so I told her what we were doing. She said, I'm going to try to make it. So I gave her my business card that has my website on it, but she should be able to get over here from there. I told her it was on YouTube, and we'll see if she can make it. Hello, Little Lone Prepper. Welcome. So anyhow, this is kind of interesting. Article 2. I caught something. I'm surprised that it's gotten past me for so long. But you're going to find out there's a couple things we don't do the way we say we should be doing them. And then a big question. I said, whoa, what happens if, And so it's really kind of interesting. So let's get into Article 2. I've also got another one up here tabbed. I'm going to share that with you. Oh, let me get some light on me. Gosh, that's what I get for being late. Turn on the spotlight there. But anyhow, I have the 6 Supreme Court decisions about something that we'll be talking about here in just a minute, tabbed. And so we'll look at that when we get to that point. Okay, so Article 2, Section 1, the executive power shall be vested in the President of the United States. He shall hold his office during the term of 4 years, and together with the Vice President chosen for the same term, be elected as follows. Now, pay attention, because this is not how we do it, but this is how the Constitution says we're supposed to do it. Each state shall appoint in such a manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled by the Congress, but no senator or representative or person holding an office or of trust or profit under the United States shall be appointed as an elector. So we do that part right, okay? We've got one elector for each representative and one elector for each senator. The electors shall meet in their respective states and vote by ballot for 2 persons, okay, of whom one at least shall not be an inhabitant of the same state with themselves. So, at least one of the people that's on the ballot has to be outside of the state. And they shall make a list of all persons voted for and of the number of votes for each, which list they shall sign and certify and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. So basically what they're supposed to do is have their ballot created, who everybody voted for. I mean, for example, let's say candidate A, 54 votes, candidate B, 37 votes, candidate C, X number of votes. So then they take that whole list and take it to the Senate, where it's going to be counted. We don't do that, okay? Some states do it that way. Some states are an all or none state. So candidate A, if they get 50.1% of the popular vote, they get all of the votes of those electors. The President of the Senate shall, in the presence of the Senate and the House of Representatives, open all of the certificates, and the votes shall then be counted. The person having the greatest number of votes shall be the president. If such number be a majority of the whole number of electors appointed. And if there be more than one who have such majority and have an equal number of votes, then the House of Representatives shall immediately choose by ballot one of them for the president. So if the way that they aggregate those, okay, person A had 54, person B had 21, person C had 17. So now you take all those and you count them all up. If all of this 50 states has person A at 102 votes and person B at 102 votes, then it goes to the House of Representatives, and the House of Representatives gets to vote on which one of those two that they want. If there's still a tie, let me see. Then the House of Representatives shall immediately choose by ballot one of them for president. And if no person has a majority after that, then from the 5 highest on the list, the said House shall be in like manner choose the president. But in choosing the president, the votes shall be taken by states, the representation from each state having 1 vote. A quorum for this purpose shall consist of a member of members from 2/3 of the states, and a majority of all the states shall be necessary for a choice. So in order to do the counting in the first place, 2/3 of the states have to be present. In every case, after the choice of the president, the person having the greatest number of votes of the electors shall be the vice president. But if there should remain 2 or more who have equal votes, the president shall choose them by ballot, the vice president. So the way this was set up was whoever got the greatest number of votes became the president. Whoever had the second greatest amount of votes became the vice president. But now we run a ticket, and that ticket says that you're going to vote for president and vice president at the same time, which is really not what the Constitution had designed for us. And we have had several instances where we had a president from one party and a vice president from the other party. The Congress may determine the time of choosing the electors and the day on which they shall give their votes, which day shall be the same day throughout the United States. Here's where it's going to get a little bit tricky. No person except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of president. Neither shall any person be eligible to that office who shall not have attained the age of 35 years and been 14 years a resident within the United States. Okay, so we got 2 things we need to discuss here real quick. Kind of greasy, kind of slimy. Number 1 is a personal question I have. I've never gotten an answer to. So, president dies. Okay, and we're going to have that coming up here at the end of this, probably the next paragraph. If the president dies, then the vice president becomes president. What happens if the president and the vice president both can't fulfill the office? Then it goes to the Speaker of the House. Well, let's take a look at this. President must be 35 years old and have been a resident of the United States for 14 years. But if we go back to Article 1, Section 2, second paragraph, no person shall be a representative who shall not have attained the age of 25 years and been 7 years a citizen of the United States. So you can be a representative at 25 and 7 years. So you've lived in the United States since 18. Now the president and the vice president are both dead. You've been elected to Speaker of the House at 25, 26 years old. You're next in line to ascend to the presidency, but you can't become president because you aren't 35 years old and haven't lived in the United States for 14 years. Does that make sense? So what happens in that case? I don't know the answer to that. That's one of those interesting questions. Okay, let's go back to the beginning of this paragraph for another interesting question. Looks like a lot of good chat, but I'm missing out on it. Let me catch up here, and then we'll get into that one. Hi, Pat Butler. Welcome. Hi, KP Heathen. Welcome to you too. Been under the I'm sorry. I've been under the weather for the last 2 or 3 days. Hardly been up. Woke up and said, glad to get up time for their group and get. Oh, fantastic. Well, thank you for being here. I certainly hope you feel better. Let me see if there's anything else. Okay, we're good. Here's another touchy one. This one raised its head during the Obama administration. No person except a natural-born citizen. So if you'll remember, there was an awful lot of talk about was he natural-born or not, because there was questions about his birth certificate, whether he was born in Hawaii or born in Kenya. And I think we really overplayed that when there was something much simpler that you just have to take a look at. So define natural, and the only place in the Constitution. Hello, Rebecca. Welcome. So the only place in our Constitution that the term natural born occurs is in order to become president. So I'm going to do a share screen here, and let's take a look at some Supreme Court decisions. Okay. And we'll go here. And we're going to share. Okay, so 4 Supreme Court decisions that define, let me get back to that tab, that define a natural-born citizen, okay? So the first one is irrefutable authority is spoken. So back in before the United States, remember, a lot of what we did was based off of Montesquieu and some other early guys from France. So a lot of our ideas about a republic come from France. So then we take a look at it here, and so we talk about the definition of the term here as given in a book entitled The Law of Nations, written by Imre de Vattal, a Swiss-German philosopher of law. And in that book, the following definition of a natural-born citizen appears. So this is in the 1790s, okay, about the time that the Constitution is being written. So it says, paragraph 212, citizens and natives. The citizens are the members of a civil society bound to the society by certain duties and subject to its authority. They equally participate in its advantages. The natives, or natural-born citizens, are those born in the country of parents who are citizens. Okay, so remember that. You're natural born. You were born in the country, and that's where they messed up on all this stuff about the Hawaii birth certificate. And are those born in the country of parents who are citizens, okay? So both parents have to be citizens of the country in order for you to be natural born. So if we take a look at the Venus, 12 U.S. 8, Cranch 253-253, Supreme Court decision in 1814, and it lists who all the Supreme Court justices were that made this decision. Remember, back at this time, there were only 7. We didn't have 9 until, I'm sorry, I covered that up. Remember, these are all Supreme Court justices involved in this decision. They were all either members of the revolution or their parents were members of the revolution. So that's how close we are to what they were fighting for. And John Marshall, of course, is one of the most famous. But they said, basically, let me get down here. The Venus case regarded the question whether the cargo of a merchantman named the Venus, belonging to an American citizen and being shipped from British territory to America during the War of 1812, could be seized and taken as a prize by an American privateer. But what the case said about citizenship is what matters most, okay? It says down here, the citizens are the members of the civil society bound to the society by certain duties and subject to its authority. Remember this from de Vattal that we mentioned a little bit earlier, that book that was internationally accepted. So now we have a Supreme Court quoting it. They equally participate in its advantages. The natives or indigenous are those born in the country of parents who are citizens. So society not being able to subsist and to perpetuate itself, but by the parents, but by the children of the citizens. God, my mouth is not working. Okay. So then that was challenged again in 1830. So Shanks versus DuPont, 28 U.S. 3, Pete 242, 242. Okay. And it says down here, if she was not of age. So what happens is you got the DuPonts. One sister went back to England. One sister stayed here. Which one, when the parents passed away, does the inheritance go to? So they were trying to figure out citizenship and everything else. And so what they said was here, this line right here, if she was not of age, then she might well be deemed under the circumstances of this case to hold the citizenship of her father. For children born in a country continuing while underage in the family of the father partake of his national character as a citizen of that country. So basically what it's saying is, if you don't have natural born citizenship, then you are to assumed to be a citizen of the country that your father is a citizen. Does that make sense? Okay, then the last one here. In 1875, next to last, Minor versus Hepperstedt, 88 U.S. Code, or 88 U.S. 162. And it says, the Constitution does not in words say who shall be natural born citizens. Resort must be made elsewhere to ascertain that. At common law, with the nomenclature of which the framers of the Constitution were familiar, it was never doubted that all children born in a country of parents who were its citizens became themselves upon their birth citizens also. These were called natives or natural born citizens. Then in the last case, the United States versus Wong Kim Ark, 169 U.S. 649 in 1898, and it says, at common law, with the nomenclature of which the framers of the Constitution were familiar, it was never doubted that all children born in a country of parents who were its citizens became themselves upon their birth citizens also. These were natives or natural born citizens. Okay. So there we've got international law, plus we have 4 Supreme Court decisions. And what they say is, guess what? In order to be a natural born citizen of the United States, yes, C-section counts. It doesn't say anything about how the delivery took place. In order to be a natural born citizen and therefore eligible to be president, you must have been born in the United States of parents who are U.S. citizens. So now we have to ask the question, let's forget about the Hawaiian birth certificate and everything else. Barack Obama's father was a citizen of what country? United States? No. His father continued to be a citizen of the country of Kenya, and was so until his death. After his mother divorced Barack's father, Barack Obama Sr., she married an Indonesian. So now we have a foster father, okay? So Barack Obama had 2 fathers, and neither one of them was a citizen of the United States. So if we read this literally and we take the 4 Supreme Court decisions of the 19th century, we take the international common law of the 18th century, all of these say that in order to be a natural born citizen, you must have both parents citizens of the U.S. His father was not a citizen of the United States. Therefore, according to this, and according to those 4 Supreme Court decisions, he was ineligible to be president of the United States. So that is a very good question, Cats and Prepping. Very good question. I think it's because people got tired of it, and people got very entrenched in the Hawaiian birth certificate thing, and that was, in my opinion, that was hokey from the start. I think people just got tired of it and said, "Forget it. Let's move on." Now, on the other hand, they were, if you will remember, just one election prior to that, or no, it was the first case of opposition. The opponent running against Barack Obama was John McCain. And there was a whole bunch of questioning about whether or not John McCain was eligible for citizenship because he was born at the U.S. Naval Base Panama Canal. So that was a U.S. protectorate. That was U.S. territory at that time. And so did that qualify for being a natural-born citizen as born in the United States? So does the born in the United States have to be in the continental United States, or can it be in a possession or a protectorate or a territory of the United States? And so that, that caused quite a stir. And I think everybody got kind of, uptight about this whole citizenship and natural born citizenship and everything else. And so I think people just got tired of discussing it, to be honest with you. Okay. So in case of removal of the now this has been superseded, by the 25th Amendment. In case of the removal of the president from office or of his death, resignation, or inability to discharge the powers and duties of the said office, the same shall devolve on the vice president, and Congress may by a law provide for the case of removal, death, resignation, or inability, both of the president and vice president, declaring what officer shall then act as president, and such officer shall act accordingly until disability may be removed, or a president shall be elected. Now, this part was not amended, okay? The president shall at stated times receive for his services a compensation, which shall neither be increased nor diminished during the period for which he shall have been elected. So no president can sign a bill giving himself a pay raise, is basically what that says. And he shall not receive within that period any other emolument from the United States or any of them. So you can't receive a gratuity, let's say, from the federal government or from any of the states. Section 2, the president shall be commander-in-chief of the Army and Navy of the United States and of the militia of the several states. Now we call those an organized militia, the National Guard, and a non-organized, rather instead of disorganized, a non-organized militia, which is basically the Minutemen, between ages 18 and 65. Okay. And that's going to become important. You remember that because it's going to be part of a preamble to the Second Amendment. Okay. And people say, well, that only applies to the National Guard. And I'll show you the two bills that we've had that say no, any male between 18 and 65 is a member of the militia. Let me see here. So when called into the actual service of the United States, he may require the opinion in writing of the principal officer of each of the executive departments upon any subject relating to the duties of the respective offices. He shall have power to grant reprieves and pardons. This came up an awful lot in 2000. Okay, a whole bunch of people were saying that if President President Trump got reelected, he was going to pardon himself. So this is straight out of Section 2, the end of paragraph 1. He shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. It doesn't matter who gets impeached, the president cannot pardon that impeachment. Okay? But it's okay to get gratuities from elsewhere or no. No. So basically, you cannot get gratuities from the federal government or from the states, okay? They've expanded, they broadened the interpretation of that to be or from private citizens and also from foreign governments. So that has been expanded by U.S. law that the Congress passed. It's not necessarily constitutional. According to the Constitution, yes. If somebody wanted to give you a donation, then that was fine. We're going to get into a little bit tricky area of that here in just a minute. We're going to, about 2 paragraphs down, we're going to talk about that a little bit more. Okay. But basically under that initial clause there, it only prohibits receiving donations or gifts from the federal government and from the state governments. He shall have the power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur, and he shall nominate and by and with all the advice and consent of the Senate, appoint ambassadors, other public ministers and councils, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise prohibited for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper in the president alone, in the courts of law, or in the heads of departments. Okay, so let's take a look at the military, because this is really kind of weird. So remember, it says here that he shall appoint all other officers of the United States. So basically, with the consent of the Senate. So basically, a commissioned officer in the United States military who is handed a commission by Congress to act as an officer under the authority of the President of the United States. Okay. And so that commission basically says the President has appointed you this commission to act as an officer of the United States. The Senate has approved, therefore you are. Okay. I think I may have passed over a paragraph. I did. I need to get back to that here in just a minute, because it's going to also become important. I'm going to kind of quote mine to you. But so then the Army has the authority to appoint. So you have commissioned officers appointed by the President and then approved by the Senate. Then you have non-commissioned officers. So the non-commissioned officers are appointed to give authority over the other enlisted ranks in the military, and that's only by the department of the service that they belong to. So the Navy makes petty officers, the Army makes non-commissioned officers, the Marine Corps the same thing. Okay, so those generals have the authority to appoint sergeants and corporals and master sergeants and all that kinds of stuff. Now, in the middle, in between a commissioned officer and a non-commissioned officer, is a warrant officer. So a warrant officer is granted a warrant by the President to act as a commissioned officer, but does not have the approval of the Senate. Okay, so I was given a warrant to act as an officer, pretend to be one, by the President that appointed me as a warrant officer. And then, just as I was retiring, that was changed so that now chief warrant officers, I was a W3, chief warrant officer 3, and so CW2 and above now are all commissioned officers. So when you become a warrant officer, you become a commissioned officer, with the exception of W1, and he's considered the same thing as basically a midshipman or a what do they call them? Plebe? No. What are they called for the Army? I know what they're called for the Navy. And I'm not even Navy, I'm Army. Cadet at West Point. Okay. So basically a W1 is about the same as a cadet at West Point, which is, but he still has more authority than a sergeant major. So you've got, from private up to sergeant major, and then from sergeant major, you got the warrants, W1 through master warrant 5. So you got W1, CW2, CW3, CW4, MW5, Master Warrant Officer 5. One of the guys I served with in Germany, Jim Ramge, he got called back to active duty right after Desert Storm. We had both retired, and I had medical disabilities and couldn't be recalled, and he didn't. He got called back, and he stayed, and he retired as an MW5. So an MW5, so we in the military, you have company grade, field grade, and general grade officers. So it's divided into 3 different grades. And each one, the first 6 are divided into 2 groups of 3. So you have second lieutenant, lieutenant, and captain are considered company grade. And then field grade, and they have the spaghetti on their hats. So with a company grade officer, their brim on their hat is solid black. They have the gold tassel around the side, but they do have solid black cap. Field grade officers have the gold tassel along the side, but they also have this we call it spaghetti or scrambled eggs on the bill of their hat. And that shows that they're a field grade officer. They command those company grade officers, and that's major, lieutenant colonel, and colonel. So basically what they've done is they've said a W1 equals an O1, or so W1 equals a second lieutenant, W2 equals a first lieutenant, W3 equals a captain, W4 equals a major, and W5 equals a lieutenant colonel. So that's basically equivalent of authority. And so he retired basically as a lieutenant colonel. I would have been considered a captain had I been under that system. Okay, enough of a diversion. But anyhow, that's where that authority comes from, that the Army can basically have their own officers and non-commissioned officers, as can the others. Okay, so let's go back. Section 1, at the end of it, I didn't do this, and I should have. And now I'll give you mine as an enlisted man. Before he enters the execution of his office, he shall take the following oath or affirmation. I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. That oath is pretty much the one that is used for non-military across the board. Okay, except that they, instead of President of the United States, they put in, Secretary of Defense or Supreme Court Justice or something like that. Okay. On the other hand, in the military, the oath is slightly different. I do solemnly swear that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, and bear true faith and allegiance to the same. That I will obey the orders of the officers appointed over me, and I will obey the orders of the President of the United States and the officers appointed over me in accordance with the Uniform Code of Military Justice, so help me God. So that's the military oath, okay? So it's a little bit different from the civilian oath. Okay. We are at the end of Section 2. The President shall have the power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session. So, and remember, back then, the idea was representatives and senators. Senators are going back to meet with their legislatures because that's who appointed them. They represented the states, not the people. Representatives went back and talked to their constituents, the people. They only conducted business in D.C. for a very short period of time and then went back to their people, okay? And that's how that's how it was envisioned it would work. Now, all their time is in D.C. and they very seldom come back and talk to us. Also, I think it's the 17th Amendment, or is it 22nd, changed it so that senators now represent the people. They're elected by the people and not appointed by the legislatures. I wish we could go back to the old way, because that basically took the guts out of the 10th Amendment. But anyhow, so that what that says is, if, let's say, the Secretary of Defense passes away, has a heart attack, and the Senate is in recess, so they're taking their vacation, they've all gone home for a while, there's nobody there to appoint a new, or to approve, 2/3 majority approval of the President's nomination of the new Secretary of Defense. So that nomination, he is an interim Secretary of Defense until the Senate comes back into session. Then they have that entire session to either appoint or not appoint, with 2/3 vote, the person that the President has nominated. So what happens if on the last day of their session, before they go into recess again, they don't appoint them, they don't approve it, okay? Then they go into recess. President now has the authority to appoint a new person or appoint the same person all over again as an interim, and we could do this forever and ever. So just kind of weird stuff, okay? Hello, Phreoxerus, welcome. Section 3. He shall from time to time give to the Congress information of the state of the Union, and recommend to their consideration such measures as he shall judge necessary and expedient. Now, we have gotten into a habit since FDR, that we give the State of the Union annually, but there's no constitutional requirement that we do that, okay? That's at their discretion, at his discretion. He could even do it more than once a year if he wanted to. On extraordinary occasions, convene both houses or just one of them And in case of disagreement between them with respect to the time of adjournment, he may adjourn them to such time as he shall think proper. So the president has the authority to either call senators back, House of Representatives back, so that they are now in session in DC, or he can say, hey, you guys aren't doing what you need to be done. You're in adjournment. Just get out of here. Go do something productive. Come back later when you're ready to work together. I don't think I've ever seen the president do that, but he has the authority to do that. He may adjourn them to such time as he shall think proper, and he shall receive ambassadors and other public ministers. He shall take care that the laws be, now this is really important, he shall take care that the laws be faithfully executed. So if we have a law on the books that says that in order to cross our border, you must apply, and then once you are applied, be given a swift and prompt adjudication, and then either expelled or accepted. Constitution says if that's the law, the president has an obligation to follow it. And so that's part of what they've been talking about. Is it an impeachable offense that our borders are wide open? I'll let you be the judge. And shall commission all the officers of the United States. Okay. Section 4, and this is the last section of Article 2. The president, vice president, and all civil officers of the United States shall be removed from office on impeachment for and conviction of. Now, remember earlier, we talked about he can't accept money from the federal government or from the states. So here we go. I'm going to read that again. The president, vice president, and all civil officers, so military is excluded, of the United States shall be removed from office on impeachment for and conviction of. Impeachment is done in the House of Representatives. Conviction is done in the Senate. Remember that from Article 1. Okay. And those are treason, bribery, or other high crimes and misdemeanors. Now we have to remember treason. Okay. The definition of treason. I forget where it is. But no person shall be convicted of treason except upon witness of two individuals. That be two eyewitnesses that the treason occurred, and it has to be direct aiding and abetment of the enemy in the overthrow of the United States. So, we throw around the word treason or traitor quite a bit in our vocabulary, but the Constitution defines it very specifically. Let me look it up just real quick. I think this is also very important. Constitutional definition of treason. There we go. It's first one. Didn't even have to type in treason. Okay. Treason is the only crime that's defined in the U.S. Constitution according to Article 3. Okay, so that'll be when we get into the judicial next week. Section 3. Treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of two witnesses to the exact same overt act or on confession in open court. So by Constitution, that's the definition, okay? Treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of two witnesses to the same overt act or on confession in open court. Okay, so we use the word quite a bit. You hear a lot of people saying he's a traitor, that's treasonous, that's everything else. We've got to adhere to the Constitution, as to what the definition of treason is. Now, we can say that was a high crime or that was a misdemeanor, and impeachable offense or something like that. But to say that he's a traitor or he's treasonous is not necessarily an accurate description according to the Constitution. So that's it for Article 2. Let's check the chat and see what you have as far as questions or concerns or comments. I don't know why I put those back on. I'm not going to be reading down there. I'm going to be reading up here. Isn't that the truth? Yes, ma'am. I wholeheartedly agree with you. That would be more of a boon than a bane. Exactly. And so now, remember that here at the end of Article 2, okay, we have another clause that's thrown in there in Section 4. The president, vice president, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, and we've already discussed that. That's Article 3, Section 3. Bribery. What is bribery? Now, this is where Congress gets to define it, okay? So what is bribery? Well, that's accepting money from somebody in order to do something that's through the legislative or executive processes or judicial processes that is advantageous to the person who is giving the money or valuable things. So that's bribery. So we have for the president, right? He can be impeached for bribery, but that's got to be defined by Congress. Hello, Sumi. Welcome. Always good to see you. I don't know the answer to that question, Cats and Prepping. Does faithfully have a legal definition? There's if you, and I strongly recommend you read it. The articles of gosh. Oh, my mind is not. Can you tell I've been running solid to get here in order to get this done? The book that John Jay and Alexander Hamilton and probably Benjamin Franklin Anonymous wrote. Oh, the Federalist Papers. There we go. So if you remember in the Federalist Papers, and later on even John Adams said that our country was written by a moral, religious group of men and could only be properly enforced by a moral, religious group of men. So I think men there meant human, not necessarily males, but I do believe moral and religious. Religious in the sense of not what religion, but that you do have a higher code that has a differentiation between right and wrong. So I think there was a commonly accepted interpretation of what faithfully and morally and those types of words that are abstracts to us today, what they actually meant back then. I think they had significant meaning back then, and they've come to the point where they mean nothing today. Great question. So that's the question that has to be asked and answered during the impeachment proceedings. Okay, so if we take a look at the first impeachment proceeding of President Trump, the allegation was that a whistleblower, an anonymous person, overheard the conversation between President Trump and Zelensky or one of the other officials in Ukraine, and that he had said that unless something happened, he was not going to give him the money, or he'd only give him the money if they did something, which in essence was a bribe. The president was attempting to bribe the foreign country. So then, based on that hearsay evidence, okay, that's where the impeachment started. Was they were impeaching him for using his power and position for personal gain, is what the original charge was. And so there were several constitutional violations. Number one, he never got to face his accuser. We still to this day don't know who the person is that accused him of this. We assume that it was Lieutenant Colonel Vindman. there were only 5 people who overheard the conversation, who heard the conversation. And they didn't expect the president to release the tape of the conversation and said, here it is, tell me where this happened. Okay. But they proceeded with the impeachment anyway, based on an anonymous person's hearsay evidence that there was no evidence presented for it. So because of that, that's why the Senate couldn't convict him. There was no evidence. So that's how that process works. Is they get to determine what the crime is. They also get to determine what the evidence to support that is. And then so think of the impeachment process in the House as being an indictment process. A grand jury indicts. Then once they have that indictment, then they send them to the trial. And that's where the judge, the district attorney, and the defense attorney all have their thing and say whether or not anything's going to happen. So that's the same thing. The House of Representatives is the indictment, is the grand jury. They send it over to the Senate, and the Senate, it basically becomes the jury and the trial and all that kinds of stuff, and the judge, jury, all that kinds of stuff. And let me get back up here. I've got to get this mouse out because there we go. It's finally came back up. The scroll bar, for some reason, I just don't like them here on these apples. Right now, it appears that, yes, there is a chance that bribery can be a basis for an indictment in the House right now. You may, but remember, we have to use the strict definition of what treason is. It's bearing arms against the United States or aiding and abetting a foreign enemy who is at war with the United States, and there have to be 2 witnesses to that. So that's, when we don't follow the definitions of words and we start expanding them and allowing other things to creep in, that's when we get in trouble. And that becomes a slippery slope. Then all of a sudden is not following the laws of the United States treasonous? Is that because you're not following the laws? Is that giving a power to a foreign adversary? We need to stick to the exact definitions. Yes, ma'am. Well, don't forget that what President Trump was impeached for, okay, based on hearsay evidence, we have video of Vice President Biden bragging about doing the exact same thing, that he told the president of Ukraine, either fire the district attorney who is investigating my son and my son's company, Burisma, or you don't get the $6 million that we had promised you. And he says, SOB. By the time I got to the airport, he had lost his job. And so he's bragging about doing it, and we haven't done anything about that. But yet on hearsay evidence, we impeached the other one. It kind of shows you the kangaroo court system we currently have in our country. I'm not going to say treasonous, but I will say I agree that a broken oath, if you don't, I would call that a high crime. Remember, we have high crimes and misdemeanors is also another impeachable offense. So I would say that breaking your oath of office is a high crime. That I wouldn't call it treason, but I would call it a high crime and impeachable offense. Cats and prepping, it could, but in this case, for example, where we're talking about bribery. I think bribery, the difference between a felony and a misdemeanor is a certain price amount. I don't know if we have that established in the federal. I'm not an attorney, so I don't know if we have that in the judicial system or not. I don't know. But pretty much high crimes and misdemeanors is also open to interpretation by the House and to the Senate. So that's pretty open-ended as to what they can do with that. Hello, WD. Glock and roll. All right. Yes, absolutely. Hearsay is always the number one cause that we should seek out for anything as far as oh, Princess Kicking Butt made it in. Fantastic. Good to see you. Okay, so enough of the Article 2 of the Constitution, and I hope that gives you some ideas of what's going on. So next week we're going to be talking about Article 3, which is the judicial system. So remember that we had the way it was set up originally was we had 7 justices on the Supreme Court, and then there was, you always want an odd number because that way, if you have a vote, you're going to have 4-3, and you've got a majority that way. You can't have an even number of justices on the Supreme Court. So it just so happens that it was 4-3 against FDR. So he was in the minority. So what he did was he had the Senate redefine the Supreme Court so that instead of having 7 senators, it had 9 senators. And so he was allowed to appoint 2 new senators. So instead of having a 4-3 court against him, he now had a 5-4 court in his favor. And so that's the same thing that we see going on now. They're talking about wanting to add some more justices to the Supreme Court so that President Biden can get people in who would be more supportive to him. And they call that packing the court. And so that's what they're trying to do. Then they're trying to also do the same thing. We'll talk about how a state becomes a state later on in the Constitution. But there was, I believe it was Kentucky. They brought in, not in the same system as in the Constitution. And so they're talking about bringing in DC and Puerto Rico as states, the same way they did Kentucky. I believe it's Kentucky, because that way it would give one party 4 more senators, and they would have permanent control of the Senate, because the Senate's been, plus or minus 1. We've had a 51-49 split in the Senate, or a 50-50 split in the Senate now for the past 23, 25 years. So it's been very, very close in the Senate. Remember, Harry Reid, in order to pass Obamacare, had to suspend the rules. So our government is designed by Constitution to be very slow in changing laws, so that it has to be very well thought out. It has to be very well approved by the vast majority. And that's why the Senate had a 2/3 rule for almost everything they did. They had to have 2/3. And Harry Reid suspended that so that they only had to have a simple majority of 51 votes in order to pass Obamacare. If he had not suspended the rules, then they would have never had the 2/3 majority to pass Obamacare and get it over to the president for signature. So, we see all kinds of strange machinations going on that kind of violate the Constitution itself. Let me catch up let me get rid of all these alerts over here and plug my computer in. So I'm getting a low battery warning. Okay. Oh, wow. It brightens up too. Absolutely, Holly. Absolutely. And now, theoretically, we have that. We have the House Oversight Committee, we have the Senate Oversight Committee, but they aren't allowed to do their jobs, because once it gets out of committee, then you have to have 2/3 in the Senate, and you have to have a simple majority in the House, and that's difficult to do. There's been some Supreme Court decisions here in the last couple days that some of the boundaries for voting districts and congressional representative districts in, I think, Minnesota and Georgia and maybe Ohio have to be redrawn because they were determined to have been redrawn incorrectly, giving one party an advantage. The new Supreme Court says that there must be, in every state, 2 districts that give a minority majority. So whatever a minority group is inside that state, at least in 2 districts of that state, represented by a congressman, they have to have a majority of that minority in that voting district. So that there's a possibility of guaranteeing that the minority always has at least 2 seats representing in that state. Now, that's going to be kind of hard with a place like Wyoming that only has 1 representative. No, the VP has not impressed me with anything she's done. I'm very happy with her staying out of the limelight and staying over at the Naval Observatory. Just, stay there and we'll all be happy. And you're absolutely right, Sumi. I think that the document, it's an experiment. It's a 250-year-old experiment, and it's ongoing. We continue to learn from it, but I do think that it is the best document that is out there. Now, I will say that there are other countries who have adopted things as well and learned from our Constitution, and that there are other countries that are just as well off in representing the people as we are. Okay, and there are some who try to be and don't quite accomplish it. But all in all, I think we are very lucky to be citizens of the country in which we are. That I can't pick of any other place that I would rather be than here, to be totally honest with you. You are so right, Princess Kicking Butt. I had a discussion with one of the people in a group I belong to, and they had our county has a Confederate soldier statue on the South Lawn, and so one guy said that the students from the university in that town are afraid to go downtown to shop because of this Confederate soldier statue. And I was just thinking, I wonder how many people that Confederate soldier statue has mauled over the course of the years. But anyhow, so they were going to have this big thing, this big tear down the statue rally at the South Lawn of the courthouse. And I said, I have no interest in going. Well, you need to go. We need to take it down. Why? It's illegal. Okay, what's the law? Nobody could tell me what the law was. So I spent 3 hours on YouTube trying to find, I'm not on YouTube, on Google, DuckDuckGo, trying to find the law that says it's illegal to have a Confederate statue on a county courthouse lawn. Can't find it anywhere. No state law, no county law, no federal law, no law. It's not illegal. So then they said, well, but you're paying homage to a traitor of the United States. I said, why is he a traitor? Well, he broke the law and seceded from the Union. I said, there was no law saying you can't secede from the Union. She says, oh, yes, there was. So she sent it to me. And it was passed in 1869. Well, Civil War, or war between the states, or the War of Northern Aggression, as those of us in the South call it, was from 1861 to 1865. So I said, oh, yeah, to the victors go the spoils. So 4 years after the war was over, they passed a law saying it's illegal what you did 9 years ago. Okay. So same thing, as a kangaroo court, make up the law after it's been broken, and so that you can enforce the rule on somebody you don't like. And that same person who wanted me to go protest at the South Lawn, he saw my hat. And so my hat has Army Security Agency, Cold War veteran. And Army Security, if you put the Army Security Agency, the Naval Security Group, and the Air Force Security Service all in the same building, it changes names and becomes the National Security Agency. And so he said, oh, well, you've got experience with classified things. What do you think about all the documents that Trump stole? I said, well, I'll tell you what. When we start enforcing the laws equally, the BlackBerry that Hillary Clinton smashed, the server that she had unguarded out in her garage with ungodly access to TSSI, top secret special intelligence information, and then of course you had Bill Clinton and what was his chief of staff's name. In order to go into a skiff, you have what's called a 2-man rule. So you have to have 2 people in the skiff at all times to keep eyes on each other. And so his chief of staff went in and removed a whole bunch of documents from the SCIF that were derogatory to President Clinton, and he got caught. So, but they accidentally, all these TSSI documents accidentally fell into his socks and his underwear, right? Just accidentally fell off the table into his socks and underwear. And so I said, when we start prosecuting those, then I think we should start prosecuting President Trump. When we start prosecuting the documents that were found in the garage of President Biden, and at that time he was vice president when he had those documents, did not have declassification authority, then we should start, now, if you're going to do one, do them all the same. In my opinion, they're all violations. They are all culpable, and they should all be given some sort of punishment for mishandling classified information, because I dealt with it. I think that would be the proper thing. Indict them all, try them all. Use the same methods against all of them. Be equal and fair. Don't pick which ones you're going to enforce and which ones you're going to indict. That to me is that's kangaroo court, like you said. I don't know. West Virginia was seceded from the secession of Virginia. I think that was another special case. So basically, West Virginia broke away from Virginia. Let me see. So I'm doing a search. State admitted to the U.S. by a non-standard. See if I can read this real quick. But it talks about, so we're talking about the so west of the Appalachian Mountains. I'll tell you what, I'll look it up. I don't want to waste time here this evening. I will look it up and I'll have a definite answer for you. It was either Kentucky, it might have been Tennessee. It was one of those Appalachian states. It could have been West Virginia, but I think West Virginia was special because that's the only one that broke off from a state that was seceding from the Union, and they wanted to stay with the Union. I love your dad, Princess Kicking Butt. He is absolutely correct. We need to have a majority, at least a 2/3 majority instead of a simple majority. I wholeheartedly agree with him. So yes and no. He doesn't decide what is classified. He decides what he can. The president has declassification authority. Okay. So there's AR 380-5, USASA Reg 380-6. There's certain documents inside of each one of the agencies. There's U.S. law. You're asking me to look back 50 years, 40 years. I forget the U.S. There's two U.S. laws on U.S. codes on classifying documents and what constitutes classifying them. It even gives the definition of confidential, secret, top secret. Okay, so all that's done administratively. The president has authority to declassify. So if I take a document to the president and it's classified top secret because I broke a code, and we don't want the enemy to know that I broke their code and I'm reading what they're doing in their transmissions, right? That's the reason why you protect that is top secret. So you don't give away secrets to the enemy. So I hand that to the president, and him divulging this could stop a war. Okay. He has the authority at that time as president to say, you know what? Them knowing that I'm reading their mail is less important than us stopping a world war. So I'm declassifying this. I'm going to make it public to the world. And when they say, how do you know that? I will have to tell them exactly how I know it. That's where he has that declassification authority. He can say, you know what? In my opinion as president, it's more important that we do this than to safeguard the protection of the document itself. Okay, so that's the declassification authority that the president has. And yes, the president has it, not the vice president. So good catch there. So he can declassify, but technically he can't classify unless it meets one of the prerogatives or one of the prerequisites, I should say, of a classification guideline. Otherwise, you could take stuff that was personal, like Hillary did, and classify it because, personal stuff, and just say this is classified, you can't have access to it, like on her BlackBerry. And that's the reason why you can't have classification authority. It has to be vested in another authority. Okay, so that's pretty much it. Gosh, we're an hour. I thought we were going to be done 15 minutes early, and now we're 5 minutes over. So let me go to numbers here. So tomorrow night, we're going to be looking at 2 chapters of nuclear war survival skills. And I'm looking forward to that tomorrow night. That's going to be one of them, I know for sure, is on radiation detectors. And the other one is going to be on lighting. I'm not sure what the 2 chapters are, but those are the titles of them. Radiation detection and lighting. And, oh, by the way, real good video today about $1 million bunker that Atlas Survival Shelters out of Dallas was going through in a foreign country. And what a fantastic bunker. Wow. So if you get a chance, go to Atlas Survival Shelters and take a look at his video. Really neat. So, no, that's Ahab in the Behu. I don't want Ahab in the Behu. I want this one. So this is how you shall bless the Israelites, saying to them, the Lord bless you and keep you. The Lord let his face shine upon you and be gracious to you. The Lord look upon you kindly and grant you peace. So remember that we're all in this together, so we can come out the other side together. Please be kind, polite, and respectful to each other, because togetherness is the key. Next week, Article 3, the judicial branch. Take care, everybody. Have a great evening. Stay safe. Keep your heads up. Bye-bye.